committee to order. General Alexander, Deputy General Cole, Chris Inglis, Director Joyce, thank you for appearing before us today on short notice. That was all the nice things we said about you. That's why we turned the microphone off. Still not working? All right. Hold one for technical difficulties.
Can you hear me?
Testing.
Now it's working.
Well, the committee will come to order. General Alexander, Deputy Attorney General Cole, Chris Inglis, Deputy Director Joyce, and Mr. Litt, thank you for appearing before us today, especially on short notice. The ranking member and I believe it is important to hold an open hearing today, and we don't do a tremendous amount of those, to provide this House and the public with an opportunity to hear directly from you how the government is using the legal authorities that Congress has provided to the executive branch since the terrorist attacks of September 11th, 2001. I'd also like to recognize the hard work of the men and women of the NSA and the rest of the intelligence community who work day in and day out to disrupt threats to our national security. People at the NSA in particular have heard a constant public drumbeat about a laundry list of nefarious things they are alleged to be doing to spy on Americans. All of them wrong. The misperceptions have been great. Yet they keep their heads down and keep working every day to keep us safe. And General Alexander, please convey our thanks to your team for continuing every day, despite much misinformation about the quality of their work. And thank them for all of us for continuing to work to protect America. I also want to take this moment to thank General Alexander, who has been extended as National Security Advisor in one way or another 3 different times. That's a patriot. This is a very difficult job at a very difficult time in our history. And for the general to accept those extensions of his military service to protect this nation, I think with all of the misinformation out there, I want to thank you for that. Thank you for your patriotism. Thank you for continuing to serve to protect the United States. And you have that great burden of knowing lots of classified information you cannot talk publicly about. I want you to know thank you on behalf of America for your service to your country. The committee has been extensively briefed on these efforts over a regular basis as a part of our ongoing oversight responsibility over the 16 elements of the intelligence community and the National Intelligence Program. In order to fully understand intelligence collection programs, most of these briefings and hearings have taken place in classified settings. Nonetheless, the collection efforts under the Business Records Provision and Section 702 of the Foreign Intelligence Surveillance Act are legal, court-approved, and subject to an extensive oversight regime. I look forward to hearing from all of the witnesses about the extensive protections and oversight in place for these programs. General Alexander, we look forward to hearing what you're able to discuss in an open forum about how the data that you obtain from providers under court order, especially under the Business Records Provision, is used. And Deputy Attorney General Cole, we look forward to hearing more about the legal authorities themselves and the state of law on what privacy protections Americans have in these business records. One of the frustrating parts about being a member of this committee, and really challenged, is sitting at the intersection of classified intelligence programs and transparent democracy as representatives of the American people. The public trusts the government to protect the country from another 9/11 type attack, but that trust can start to wane when they are faced with inaccuracies, half-truths, and outright lies about the way the intelligence programs are being run. One of the more damaging aspects of selectively leaking incomplete information is that it paints an inaccurate picture and fosters distrust in our government. This is particularly so when those of us who have taken the oath to protect information that can damage the national security if released cannot publicly provide clarifying information because it remains classified. It is at times like these where our enemies our enemies within become almost as damaging as our enemies on the outside. It is critically important to protect sources and methods so we aren't giving the enemy our playbook. It's also important, however, to be able to talk about how these programs help protect us so they can continue to be reauthorized, and then we highlight the protections and oversight of which these programs operate under. General Alexander, you and I have talked over the last week about the need to be able to publicly elaborate on the success stories these authorities have contributed to without jeopardizing ongoing operations. And I know you'll have the opportunity to talk about several of those today. I place the utmost value in protecting sources and methods, and that's why you've been, I think, so diligent in making sure that anything that's disclosed comports with the need to protect sources and methods so that, again, we don't make it easier for the bad guys overseas, terrorists in this case, to do harm to United States citizens, and I respect that. I also recognize that when we are forced into the position of having so publicly discussed intelligence programs due to irresponsible criminal behavior, that we also have to be careful balance the need for secrecy while educating the public. I think you have struck the right balance between protecting sources and methods and maintaining the public's trust by providing more examples of how these authorities have helped disrupt terrorist plots and connections. I appreciate your efforts in this regard. For these authorities to continue, they must continue to be available. Without them, I fear we will return to the position where we were prior to the attacks of September 11th, 2001, and that would be unacceptable for all of us. I hope today's hearing will help answer questions that have arisen as a result of the fragmentary and distorted illegal disclosures over the past several days. Before recognizing General Alexander for his opening statement, I turn the floor over to the ranking member for any opening statement he'd like to make.
Well, I reiterate a lot of what the chairman has said. General Alexander, Chris Inglis, your leadership at NSA has been outstanding, and I just want to acknowledge the people who work at NSA every day. NSA is in my district. I have an occasion to communicate, and a lot of the people who go to work to protect our country, who work hard every day, are concerned that the public or think they're doing something wrong, and that's not the case at all. And the most important thing we can do here today is let the public know the true facts. I know that Chairman Rogers and I and other members have asked you to help declassify what we can that will not hurt our security so the public can understand that this important is legal, why we're doing this program, and how it protects us. We're here today because of the brazen disclosure of critical classified information that keeps our country safe. This widespread leak by a 29-year-old American systems administrator put our country and our allies in danger by giving the terrorists a really good look at the playbook that we use to protect our country. The terrorists now know many of our sources and methods. There's been a lot in the media about this situation, some right, a lot wrong. We're holding this open hearing today so we can set the record straight and the American people can hear directly from the intelligence community as to what is allowed and what is not under the law. We need to educate members of Congress also with the public. To be clear, the National Security Agency is prohibited from listening in on phone calls of Americans without proper court-approved legal authorities. We live in a country of laws. These laws are strictly followed and layered with oversight from three branches of government, including the executive branch, the courts, and Congress. Immediately after 9/11, we learned that a group of terrorists were living in the United States, actively plotting to kill Americans on our own soil, that we didn't have the proper authorities in place to stop them before they could kill almost 3,000 innocent people. Good intelligence is clearly the best defense against terrorism. There are two main authorities that have been highlighted in the press. The business records provision allows the government to legally collect what is called metadata, simply the phone number and length of call. No content, no conversations. This authority allows our counterterrorism and the law enforcement officials to close the gap on foreign and domestic terrorist activities. It enables our intelligence community to discover whether foreign terrorists have been in contact with people in the U.S. who may be planning a terrorist attack on U.S. soil. The second authority is known as Section 702 of the FISA Amendment Act. It allows the government to collect the content of email and phone calls of foreigners, not Americans, located outside the United States. This allows the government to get information about terrorists, cyber threats, weapons of mass destruction, and nuclear weapons proliferation that threaten America. This authority prohibits the targeting of American citizens or U.S. permanent residents without a court order, no matter where they are located. Both of these authorities are legal. Congress approved and reauthorized both of them over the last 2 years. In fact, these authorities have been instrumental in helping prevent dozens of terrorist attacks, many on U.S. soil. But the fact still remains that we must figure out how this could have happened. How was this 29-year-old systems administrator able to access such highly classified information and about such sensitive matters? And how was he able to download it and remove it from his workplace undetected? We need to change our systems and practices and employ the latest in technology that will alert superiors when a worker tries to download and remove this type of information. We need to seal this crack in the system. And to repeat something incredibly important, the NSA is prohibited from listening to phone calls or reading emails of Americans without a court order. Period. End of story. Look forward to your testimony.
Again, thank you very much. Thanks, Dutch, for that. General Alexander, the floor is yours.
Chairman, Ranking Member, thank you for the kind words. I will tell you it is a privilege and honor to serve as the Director of the National Security Agency and the Commander of U.S. Cyber Command. As you noted, we have extraordinary people doing great work to protect this country and to protect our civil liberties and privacy. Over the past few weeks, unauthorized disclosures of classified information have resulted in considerable debate in the press about these two programs. The debate has been fueled, as you noted, by incomplete and inaccurate information, with little context provided on the purpose of these programs, their value to our national security and that of our allies, and the protections that are in place to preserve our privacy and civil liberties. Today, we will provide additional detail and context on these two programs to help inform that debate. These programs were approved by the administration, Congress, and the courts. From my perspective, a sound legal process that we all work together as a government to protect our nation and our civil liberties and privacy. Ironically, the documents that have been released so far show the rigorous oversight and compliance our government uses to balance security with civil liberties and privacy. Let me start by saying that I would much rather be here today debating this point than trying to explain how we failed to prevent another 9/11. It is a testament to the ongoing teamwork of the Central Intelligence Agency, the Federal Bureau of Investigation, and the National Security Agency, working with our allies and industry partners, that we have been able to connect the dots and prevent more terrorist attacks. The events of September 11, 2001 occurred in part because of a failure on the part of our government to connect those dots. Some of those dots were in the United States. The intelligence community was not able to connect those domestic dots, phone calls between operatives in the U.S. and Al-Qaeda terrorists overseas. Following the 9/11 Commission, which investigated the intelligence community's failure to detect 9/11, Congress passed the Patriot Act. Section 215 of that act, as it has been interpreted and implied, helps the government close that gap by enabling the detection of telephone contact between terrorists overseas and operatives within the United States. As Director Mueller emphasized last week during his testimony to the Judiciary Committee, if we had had Section 215 in place prior to 9/11, we may have known that the 9/11 hijacker, Madar, was located in San Diego and communicating with a known Al-Qaeda safe house in Yemen. In recent years, these programs, together with other intelligence, have protected the U.S. and our allies from terrorist threats across the globe, to include helping prevent the potential terrorist events over 50 times since 9/11. We will actually bring forward to the committee tomorrow documents that the interagency has agreed on that in a classified setting gives every one of those cases for your review. We'll add 2 more today publicly, we'll discuss. But as the chairman noted, if we give all those out, we give all the secrets of how we're tracking down the terrorists as a community, and we can't do that. Too much is at risk for us and for our allies. I'll go into greater detail as we go through this testimony this morning. I believe we have achieved this security and relative safety in a way that does not compromise the privacy and civil liberties of our citizens. We would like to make 3 fundamental points. First, these programs are critical to the intelligence community's ability to protect our nation and our allies' security. They assist the intelligence community efforts to connect the dots. Second, these programs are limited, focused, and subject to rigorous oversight. They have distinct purposes and oversight mechanisms. We have rigorous training programs for our analysts and their supervisors to understand their responsibilities regarding compliance. Third, the disciplined operation of these programs protects the privacy and civil liberties of the American people. We will provide important details about each of those. First, I'd ask the Deputy Attorney General, Jim Cole, to discuss the overarching framework of our authority. Sir?
Thank you, General. Mr. Chairman, Mr. Ranking Member, members of the committee. As General Alexander said, and as the Chairman and Ranking Member have said, all of us in the national security area are constantly trying to balance protecting public safety with protecting people's privacy and civil liberties in this government. And it's a constant job at balancing this. We think we've done this in these instances. There are statutes that are passed by Congress. This is not a program that's off the books, that's been hidden away. This is part of what government puts together and discusses. Statutes are passed. It is overseen by 3 branches of our government: the legislature, the judiciary, and the executive branch. The process of oversight occurs before, during, and after the processes that we're talking about today. And I want to talk a little bit about how that works, what the legal framework is, and what some of the protections are that are put into it. First of all, what we have seen published in the newspaper concerning 215, this is the business records provisions of the Patriot Act that also modify FISA. You've seen one order in the newspaper that's a couple of pages long that just says, under that order, we're allowed to acquire metadata, telephone records. That's one of 2 orders. It's the smallest of the 2 orders. And the other order, which has not been published, goes into, in great detail, what we can do with that metadata, how we can access it, how we can look through it, what we can do with it once we have looked through it, and what the conditions are that are placed on us to make sure that we protect privacy and civil liberties and at the same time protect public safety. Let me go through a few of the features of this. First of all, it's metadata. These are phone records. This is just like what you would get in your own phone bill. It is the number that was dialed from, the number that was dialed to, the date, and the length of time. That's all we get under 215. We do not get the identity of any of the parties to this phone call. We don't get any cell site or location information as to where any of these phones were located. And most importantly, and you're probably going to hear this about 100 times today, we don't get any content under this. We don't listen in on anybody's calls under this program at all. This is under, as I said, Section 215 of the Patriot Act. This has been debated and up for reauthorization and reauthorized twice by the United States Congress since its inception in 2006 and in 2011. Now, the way it works is there is an application that is made by the FBI under the statute to the FISA court. We call it the FISC. They ask for and receive permission from the FISC under this to get records that are relevant to a national security investigation. And they must demonstrate to the FISC that it will be operated under the guidelines that are set forth by the Attorney General under Executive Order 12333. This is what covers intelligence gathering in the federal government. It is limited to tangible objects. Now, what does that mean? These are like records, like the metadata, the phone records I've been describing, but it is quite explicitly limited to things that you could get with a grand jury subpoena, those kinds of records. Now, it's important to know, prosecutors issue grand jury subpoenas all the time and do not need any involvement of a court or anybody else really to do so. Under this program, we need to get permission from the court to issue this ahead of time. So there is court involvement with the issuance of these orders, which is different from a grand jury subpoena, but the type of records, just documents, business records, things like that, are limited to those same types of records that we could get through a grand jury subpoena. Now, the orders that we get last 90 days. So we have to re-up and renew these orders every 90 days in order to do this. Now, there are strict controls over what we can do under the order. And again, that's the bigger, thicker order that hasn't been published. There's restrictions on who can access it in this order. It is stored in repositories at NSA that can only be accessed by a limited number of people. And the people who are allowed to access it have to have special and rigorous training about the standards under which that they can access it. In order to access it, there needs to be a finding that there is reasonable suspicion that you can articulate, that you can put into words, that the person whose phone records you want to query is involved with some sort of terrorist organizations, and they are defined. It's not everyone. They're limited in the statute. So there has to be independent evidence, aside from these phone records, that the person you're targeting is involved with a terrorist organization. If that person is a United States person, a citizen, or a lawful permanent resident, you have to have something more than just their own speeches, their own readings, their own First Amendment type activity. You have to have additional evidence beyond that that indicates that there is reasonable, articulable suspicion that these people are associated with specific terrorist organizations. Now, one of the things to keep in mind is under the law, the Fourth Amendment does not apply to these records. There is a case quite a number of years ago by the Supreme Court that indicated that toll records, phone records like this that don't include any content are not covered by the Fourth Amendment because people don't have a reasonable expectation of privacy in who they called and when they called. That's something you show to the phone company. That's something you show to many, many people within the phone company on a regular basis. Once those records are accessed under this process and reasonable articulable suspicion is found, that's found by specially trained people. It is reviewed by their supervisors. It is documented in writing ahead of time so that somebody can take a look at it. Any of the accessing that is done in an auditable fashion. There is a trail of it. So both the decision and the facts that support the accessing and the query is documented. The amount that was done, what was done, all of that is documented and reviewed and audited on a fairly regular basis. There are also minimization procedures that are put into place so that any of the information that is acquired has to be minimized, it has to be limited, and its use is strictly limited. And all that is set out in the terms of the court order. And if any U.S. persons are involved, there are particular restrictions on how any information concerning a U.S. person can be used in this. Now, there is extensive oversight and compliance that is done with these records and with this process. Every now and then there may be a mistake. A wrong phone number is hit, or a person who shouldn't have been targeted gets targeted because there's a mistake in the phone record, something like that. Each of those compliance incidents, if and when they occur, have to be reported to the FISA court immediately. And let me tell you, the FISA court pushes back on this. They want to find out, why did this happen? What were the procedures and the mechanisms that allowed it to happen, and what have you done to fix it? So whenever we have a compliance incident, we report it to the court immediately, and we report it to Congress. We report it to the intelligence committees of both houses and the judiciary committees of both houses. We also provide the intelligence and judiciary committees with any significant interpretations that the court makes of the 215 statute. If they make a ruling that is significant or issue an order that is significant in its interpretation, we provide those, as well as the applications we made for those orders, to the Intelligence Committee and to the Judiciary Committee. And every 30 days, we are filing with the FISC, with the court, a report that describes how we implement this program. It includes a discussion of how we're applying the reasonable articulable suspicion standard. It talks about the number of approved queries that we made against this database, the number of instances that the query results in containing U.S. person information that was shared outside of NSA, and all of this goes to the court. At least once every 90 days, and sometimes more frequently, the Department of Justice, the Office of the Director of National Intelligence, and the NSA meet to assess NSA's compliance with all of these requirements that are contained in the court order. Separately, the Department of Justice meets with the Inspector General for the National Security Agency and assesses NSA's compliance on a regular basis. Finally, there is, by statute, reporting of certain information that goes to Congress in semi-annual reports that we make on top of the periodic reports we make if there's a compliance incident. And those include information about the data that was required and how we are performing under this statute. So once again, keeping in mind, all of this is done with three branches of government involved: oversight and initiation by the executive branch with review by multiple agencies, statutes that are passed by Congress, oversight by Congress, and then oversight by the court. Now, the 702 statute, under the FISA Amendments Act, is different. Under this, we do get content. But there's a big difference. You are only allowed under 702 to target, for this purpose, non-U.S. persons who are located outside of the United States. So if you have a U.S. permanent resident who's in Madrid, Spain, we can't target them under 702. Or if you have a non-U.S. person who's in Cleveland, Ohio, we cannot target them under 702. In order to target a person, they have to be neither a citizen nor a permanent U.S. resident, and they need to be outside of the United States while we're targeting them. Now, there's prohibitions in this statute. For example, you can't reverse target somebody. This is where you target somebody who's out of the United States, but really your goal is to capture conversations with somebody who is inside the United States. So you're trying to do indirectly what you couldn't do directly. That is explicitly prohibited by this statute. And if there is ever any indication that it's being done, because again, we report the use that we make of this statute to the court and to the Congress, that is seen. You also have to have a valid foreign intelligence purpose in order to do any of the targeting on this. So you have to make sure, as it was described, that it's being done for defined categories of weapons of mass destruction, foreign intelligence, things of that nature. These are all done pursuant to an application that is made by the Attorney General and the Director of National Intelligence to the FISC. The FISC gives a certificate that allows this targeting to be done for a year period. It then has to be renewed at the end of that year in order for it to be re-upped. Now, there is a requirement that, again, there is reporting. You cannot, under the terms of this statute, have and collect any information on conversations that are wholly within the United States. So you're targeting someone outside the United States. If they make a call to inside the United States, that can be collected. But it's only because the target of that call outside the United States initiated that call and went there. If the calls are wholly within the United States, we cannot collect them. If you're targeting a person who is outside of the United States and you find that they come into the United States, we have to stop the targeting right away. And if there's any lag and we find out that we collected information because we weren't aware that they were in the United States, we have to take that information, purge it from the systems, and not use it. Now, there's a great deal of minimization procedures that are involved here, particularly concerning any of the acquisition of information that deals or comes from U.S. persons. As I said, only targeting people outside the United States who are not U.S. persons. But if we do acquire any information that relates to a U.S. person, under limited criteria only can we keep it. If it has to do with foreign intelligence in that conversation, or understanding foreign intelligence, or evidence of a crime, or a threat of serious bodily injury, we can respond to that. Other than that, we have to get rid of it, we have to purge it, and we can't use it. If we inadvertently acquire any of it without meaning to, again, once that's discovered, we have to get rid of it, we have to purge it. The targeting decisions that are done are, again, documented ahead of time, reviewed by a supervisor before they're ever allowed to take place in the beginning. The Department of Justice and the Office of the Director of National Intelligence conduct on-site reviews of each targeting that is done. They look at them to determine and go through the audit to determine that they were done properly. This is done at least every 60 days, and many times done more frequently than that. In addition, if there's any compliance issue, it is immediately reported to the FISC. The FISC again pushes back. How did this happen? What are the procedures? What are the mechanisms you're using to fix this? What have you done to remedy it? If you acquired information you should have you gotten rid of it as you're required? And in addition, we're providing Congress with all of that information if we have compliance problems. We also report quarterly to the FISC concerning the compliance issues that have arisen during that quarter, on top of the immediate reports, and what we've done to fix it and remedy the ones that we've reported. We also, to Congress under this program, the Department of Justice and the Office of the Director of National Intelligence provide a semi-annual report to the FISC and to Congress, assessing all of our compliance with the targeting and minimization procedures that are contained in the court order. We also provide a semi-annual report to the FISC and to Congress concerning the implementation of the program, what we've done and what we found. And we also provide to Congress documents that contain, again, how we're dealing with the minimization procedures, any significant legal interpretations that the FISC makes concerning these statutes, as well as the orders and the applications that would relate to that. And on top of all of this, annually, the Inspector General for NSA does an assessment which he provides to Congress that reports on compliance, the number of disseminations under this program that relate to U.S. persons, the number of targets that were reasonably believed at the time to be outside the United States who were later determined to be in the United States, and what that was done. So in short, there is, from before, during, and after, the involvement of all three branches of the United States government on a robust and fairly intimate way. I'd like to make one other observation, if I may, on this. We have tried to do this in as thorough, as protective, and as transparent a way as we possibly can, considering it is the gathering of intelligence information. Countries and allies of ours all over the world collect intelligence. We all know this. And there have recently been studies about how transparent our system is in the United States compared to many of our partners, many in the EU, countries like France, the UK, Germany, who we work with regularly. And a report that was just recently issued in May of this year found that the FISA Amendments Act, the statute that we're talking about here, and I will quote, imposes at least as much, if not more, due process and oversight on foreign intelligence surveillance than other countries, and this includes EU countries. And that under this, the U.S. is much more transparent about its procedures, requires more due process protections in its investigations that involve national security, terrorism, and foreign intelligence. The balance is always one we seek to strive to achieve. But I think, as I've laid out to you, we have done everything we can to achieve it. And I think part of the proof of what we've done is this report that came out just last month indicating our system is as good and frankly better than all of our allies and liaison partners. Thank you, Mr. Chairman.
Chairman, I will now switch to the value of the program and talk about some statistics that we're putting together. As we stated, these programs are immensely valuable for protecting our nation and securing the security of our allies. In recent years, the information gathered from these programs provided the U.S. government with critical leads to help prevent over 50 potential terrorist events in more than 20 countries around the world. FAA 702 contributed in over 90% of these cases. At least 10 of these events included homeland-based threats, and the vast majority, business records FISA reporting contributed as well. I would also point out that it is a great partnership with the Department of Homeland Security in those with a domestic nexus. But the real lead for domestic events is the Federal Bureau of Investigation. It has been our honor and privilege to work with Director Mueller and Deputy Director Joyce, so I'll turn it now over to Sean.
Thank you, General. Thank you, Chairman and Ranking Member and members of the committee for the opportunity to be here today. NSA and the FBI have a unique relationship and one that has been invaluable since 9/11. And I just want to highlight a couple of the instances. In the fall of 2009, NSA, using 702 authority, intercepted an email from a terrorist located in Pakistan. That individual was talking with the individual located inside the United States, talking about perfecting a recipe for explosives. Through legal process, that individual was identified as Najibullah Zazi. He was located in Denver, Colorado. The FBI followed him to New York City. Later, we executed search warrants with the New York Joint Terrorism Task Force and NYPD and found bomb-making components in backpacks. Zazi later confessed to a plot to bomb the New York subway system with backpacks. Also working with Pfizer business records, the NSA was able to provide a previously unknown number of one of the co-conspirators, Addis Medijunu. This was the first core al-Qaeda plot since 9/11, directed from Pakistan. Another example, NSA, utilizing 702 authority, was monitoring a known extremist in Yemen. This individual was in contact with an individual in the United States named Khalid Ouazani. Ouazani and other individuals that we identified through a FISA that the FBI applied for through the FISC were able to detect a nascent plotting to bomb the New York Stock Exchange. Ouazani had been providing information and support to this plot. The FBI disrupted and arrested these individuals. Also, David Headley, a U.S. citizen living in Chicago. The FBI received intelligence regarding his possible involvement in the 2008 Mumbai attacks, responsible for the killing of over 160 people. Also, NSA, through 702 coverage of an al-Qaeda affiliated terrorist, found that Headley was working on a plot to bomb a Danish newspaper office that had published the cartoon depictions of the Prophet Muhammad. In fact, Headley later confessed to personally conducting surveillance of the Danish newspaper office. He and his co-conspirators were convicted of this plot. Lastly, the FBI had opened an investigation shortly after 9/11. We did not have enough information, nor did we find links to terrorism, so we shortly thereafter closed the investigation. However, the NSA, using the business record FISA, tipped us off that this individual had indirect contacts with a known terrorist overseas. We were able to reopen this investigation, identify additional individuals through legal process, and were able to disrupt this terrorist activity. Thank you. Back to you, General.
So that's 4 cases total that we put out publicly. What we're in the process of doing with the interagency is looking at over 50 cases that are classified and will remain classified that will be brought to both the Intel committees of the Senate and the House, to all of you. Those 50 cases right now have been looked at by the FBI, CIA, and other partners within the community, and the National Counterterrorism Center is validating all the points so that you know that what we put in there is exactly right. I believe the numbers from those cases are something that we can publicly reveal and all publicly talk about. What we are concerned, as the chairman said, is going into more detail on how we stop some of these cases. As we are concerned, it will give our adversaries a way to work around those and attack us or our allies, and that would be unacceptable. I have concerns that the intentional and irresponsible release of classified information about these programs will have a long and irreversible impact on our nation's security and on that of our allies. This is significant. I want to emphasize that the foreign intelligence is the best the foreign intelligence programs that we're talking about is the best counterterrorism tools that we have to go after these guys. We can't lose those capabilities. One of the issues that has repeatedly come up, well, how do you then protect civil liberties and privacy? Where's the oversight? What are you doing on that? We have the Deputy Director of the National Security Agency, Chris Inglis, will now talk about that and give you some specifics about what we do and how we do it with these programs.
Thank you, General Alexander. Chairman, Ranking Member, members of the committee, I'm pleased to be able to briefly describe the 2 programs as used by the National Security Agency with a specific focus on the internal controls and the oversight provided. First, to remind these 2 complementary but distinct programs are focused on foreign intelligence. That's NSA's charge. The first program, executed under Section 215 of the Patriot Act, authorizes the collection of telephone metadata only. As you've heard before, the metadata is only the telephone numbers in contact, the time and date of the call, and the duration of that call. This authority does not, therefore, allow the government to listen in on anyone's telephone call, even that of a terrorist. The information acquired under the court order from the telecommunications provider does not contain the content of any communications, what you're saying during the course of the conversation, the identities of the people that are talking, or any cell phone locational information. As you also know, this program was specifically developed to allow the U.S. government to detect communications between terrorists operating outside the U.S. who are themselves communicating with potential operatives inside the U.S., a gap highlighted by the attacks of 9/11. The controls on the use of this data at NSA are specific, rigorous, and designed to ensure focus on counterterrorism. To that end, the metadata acquired and stored under this program may be queried only when there is a reasonable suspicion based on specific and documented facts that an identifier, like a telephone number, is associated with specific foreign terrorist organizations. This determination is formally referred to as the reasonable articulable suspicion standard. During all of 2012, the 12 months of 2012, we at NSA approved fewer than 300 unique numbers, which were then used to initiate a query of this data set. The second program, authorized under Section 702 of the Foreign Intelligence Surveillance Act, authorizes targeting only for communications of foreigners who are themselves not within the United States for foreign intelligence purposes, with the compelled assistance of an electronic communications service provider. As I noted earlier, NSA being a foreign intelligence agency, foreign intelligence for us is information related to the capabilities, intentions, or activities of foreign governments, foreign organizations, foreign persons, or international terrorists. Let me be very clear. Section 702 cannot be and is not used to intentionally target any U.S. citizen or any U.S. person, any person known to be in the United States, a person outside the United States if the purpose is to acquire information from a person inside the United States. We may not do any of those things using this authority. The program is also key in our counterterrorism efforts, as you've heard. More than 90% of the information used to support the 50 disruptions mentioned earlier was gained from this particular authority. Again, if you want to target the content of a U.S. person anywhere in the world, you cannot use this authority. You must get a specific court warrant. I would like to now describe in further detail some of the rigorous oversight for each of these programs. First, for the Section 215 program, also referred to as Business Records FISA, controls that determine how we manage and use the data are explicitly defined and formally approved by the Foreign Intelligence Surveillance Court. First, the metadata is segregated from other data sets held by NSA, and all queries against the database are documented and audited. As defined in the orders of the court, only 20 analysts at NSA and their 2 managers, for a total of 22 people, are authorized to approve numbers that may be used to query this database. All of those individuals must be trained in the specific procedures and standards that pertain to the determination of what is meant by reasonable articulable suspicion. Every 30 days, NSA reports to the court the number of queries and disseminations made during that period. Every 90 days, the Department of Justice samples all queries made across the period and explicitly reviews the basis for every U.S. person or every U.S. identity query made. Again, we do not know the names of the individuals of the queries we might make. In addition, only 7 senior officials at NSA may authorize the dissemination of any information we believe that might be attributable to a U.S. person. Again, we would not know the name. It would only be the telephone number. And that dissemination in this program would only be made to the Federal Bureau of Investigation after determining that the information is related to and necessary to understand a counterterrorism initiative. The Foreign Intelligence Surveillance Court reviews the program every 90 days. The data that we hold must be destroyed within 5 years of its acquisition. NSA and the Department of Justice brief oversight committees on the employment of the program. We provide written notification of all significant developments within the program. The Department of Justice provides oversight committees with all significant Foreign Intelligence Surveillance Court's opinions regarding the program. Turning my attention to the 702 program, the Foreign Intelligence Surveillance Court annually reviews certification which are required by law that are jointly submitted by the Attorney General and the Director of National Intelligence. These certifications define the categories of foreign actors that may be appropriately targeted, and by law must include specific targeting and minimization procedures that the Attorney General and the Court both agree are consistent with the law and the Fourth Amendment of the Constitution. These procedures require that a communication of or concerning a U.S. person must be promptly destroyed after it is identified, either as clearly not relevant to the authorized purpose or as not containing evidence of a crime. The statute further requires a number of reports to be provided to both the court and the oversight committees. A semi-annual assessment by the Department of Justice and the Office of the Director of National Intelligence regarding compliance with the targeting and minimization procedures. An annual IG assessment that reports compliance with procedural requirements laid out within the order. The number of disseminations that may refer to U.S. persons, the number of targets later found to be in the United States, and whether the communications of such targets were ever reviewed. An annual Director of NSA report is also required to describe the compliance efforts taken by NSA and address the number of U.S. person identities disseminated in NSA reporting. Finally, Foreign Intelligence Surveillance Court procedures require NSA to inform the court of any novel issues of law or technology relevant to an authorized activity and any non-compliance to include the executive branch's plan for remedying that same event. In addition to the procedures I've just described, the Department of Justice conducts on-site reviews at NSA to sample NSA's 702 targeting and tasking decisions every 60 days. And finally, I would conclude with my section to say that in July of 2012, the Senate Select Committee on Intelligence, in a report reviewing the progress over the 4 years of the law's life at that point in time, said that across the 4-year history of the program, the committee had not identified a single willful effort by the executive branch to violate the law.
So to wrap up, Chairman, first I'd like to just hit on when we say 7 officials, that's 7 positions at NSA can disseminate U.S. persons data. Today there are 10 people in those positions. One of those is our SIGINT operations officer. Every one of those has to be credentialed. Chris and I are 2 of those officials. I do want to hit a couple key points. First, with our industry partners. Under the 702 program, the U.S. government does not unilaterally obtain
adequate. There's theoretically no restriction on your ability to store information on anything for which I do not have a reasonable expectation of privacy.
I'll refer back to NSA.
But let me, I do have one more
feasibility
question.
to make
Yeah,
people's tech-
this is a conversation to be, I do have one more, much more specific question.
Can I hit,
Yeah.
if I could, and I'll ask for more time if I could, because I do think what you've asked is very important. So your question is, could somebody get out and get your phone number and see that you were at a bar last night? The answer is no, because first, in our system, somebody would have had to approve, and there's only 22 people that can approve a reasonable articulable suspicion on a phone number. So first, that has to get input. Only those phone numbers that are approved could then be queried. And so you have to have one of those 22 break a law. Then you have to have somebody go in and break a law. And the system is 100% auditable, so it will be caught. There is no way to change that. And so on that system, whoever did that would have broken the law. That would be willful, and then that person would be found by the court to be in violation of a court order, and that's much more serious. We have never had that happen.
Yeah, no, I thank you. I appreciate that, and I think it's really important that we explore these bright lines about what you can keep and what you can't. Again, I don't see anything about the control systems that are troubling, but I do have one last quick question, if the chairman will indulge me. And General, this is, I guess, for you, and it's something that I asked you in closed session. As we weigh this, because obviously we're weighing security against privacy and whatnot, as we weigh this, I think it's really important that we understand exactly the national security benefit. And I limit myself to 215 here. 50 episodes. I don't think it's adequate to say that 702 and 215 authorities contributed to our preventing 50 episodes. I think it's really essential that you grade the importance of that contribution. The question I asked you, and you can answer now, or I'd really like to get into this, how many of those 50 episodes would have occurred but for your ability to use the Section 215 authorities as disclosed in the Verizon situation? How essential, not just contributing to, but how essential are these authorities to stopping which terrorist attacks?
Okay, for clarity, over 50, and in 90% of those cases, FAA 702 contributed, and in 50%, I believe they were critical. We will send that to the committee.
This is 702. You're saying?
702.
Okay.
Now, shifting to the business record FISA, and I'll do a Mutt and Jeff here. I'm not sure which one I am. There's just over 10 that had it domestic. In the vast majority
10 of the 50 were
just
Section 215.
over 10 were
And of those
domestic.
10, how many would you say were critical?
No, let me
I'm
finish.
sorry, did I get it wrong?
Yeah, you do. Just slightly over 10, and I don't want to pin that number until the community verifies it, so just a little over 10, were a domestic, had a domestic nexus. And so business records FISA could only apply to those. See, so the ones in other countries it couldn't apply to because the data's not there and it doesn't come into the US. So if we now look at that, the vast majority of those had a contribution by business record FISA. So I think we have to be careful that you don't try to take the whole world and then say, well, you only did those that were in the United States and only, some large majority of that. I do think this, going back to 9/11, we didn't have the ability to connect the dots. This adds one more capability to help us do that. And from my perspective, what we're doing here with the civil liberties and privacy oversight and bringing together does help connect those dots. Go ahead, Cspan.
If I could just, I'm out of time, but I think this point is really important. If my constituents are representative of the broader American public, they're more concerned, frankly, with the Section 215 gathering of American data than they are with the foreign data. And so I really hope you'll elucidate for us, specifically case by case, how many stopped terrorist attacks were those programs, 215, essential to?
I would just add to General Alexander's comments, and I think you ask an almost impossible question to say how important each dot was. What I can tell you is post 9/11, I don't recognize the FBI I came into 26 years ago. Our mission is to stop terrorism, to prevent it, not after the fact, to prevent it before it happens in the United States. And I can tell you every tool is essential and vital. And the tools, as I outlined you in the uses today, have been valuable to stopping some of those plots. You ask, how can you put the value on an American life? And I can tell you it's priceless.
Thank you, Mr. Chairman.
Thank you, Mr. Chair, for holding this important hearing today. I just have a series of short questions. My first one is, you had mentioned earlier in your testimony that data must be destroyed within 5 years of acquisition. I believe that's in the Section 215 phone records. That's true? within
That
5
is
years.
true. It's destroyed when it reaches 5 years of age.
And how long do the phone companies on their own maintain data?
That varies. They don't hold that data for the benefit of the government. They hold that for their own business internal processes. I don't know the specifics. I know that it is variable. I think that it ranges from 6 to 18 months, and that the data they hold is, again, useful for their purposes, not necessarily the government's.
So then my question is, did the FISA orders give the United States companies a choice in whether to participate in the NSA business records or in the prison programs? Were these was this voluntary compliance on the part of these companies?
No, these are court orders that require their compliance with the terms of the court order.
So let me just, for the record, state, is NSA spying today, or have you spied on American citizens?
We do not target U.S. persons anywhere in the world without a specific court warrant.
And does the NSA listen to the phone calls of American citizens?
We do not target or listen to the telephone calls of U.S. persons under that targeting without a specific court warrant.
Does the NSA read the emails of American citizens?
Same answer, ma'am.
Does the NSA read the text messages of American citizens?
Again, we do not target the content of U.S. person communications without a specific warrant anywhere on the earth.
Has the NSA ever tracked any political enemies of the administration, whether it's a Republican administration or Democrat administration? Have either of the administrations, you said you're 100% auditable, so you would know the answer to this question. Have you ever tracked the political enemies of an administration?
In my time at NSA, no, ma'am.
Does the government keep video data, like Mr. Hines had just questioned? Does the government have a database with video data in it tracking movements of the American people?
No, ma'am.
I'm sorry, that's not, the microphone isn't on.
NSA does not hold such data.
Yeah,
Tracking.
and we don't know of any data, anybody that does. So I think those are held, as you see from Boston, by individual shop owners and street corners.
But does the federal government have a database with video
No.
data in it tracking the whereabouts of the American people?
The FBI does not have such a database, nor am I aware of one.
Does the American government have a database that has the GPS location whereabouts of Americans, whether it's by our cell phones or by any other tracking device? Is there a known database?
NSA does not hold such a database.
Does the NSA have a database that you maintain that holds the content of Americans' phone calls? Do you have recordings of all of our calls? So if we're making phone calls, is there a national database that has the content of our calls?
We're not allowed to do that, nor do we do that, unless we have a court order to do that. And it would be only in specific cases, and almost always that would be an FBI lead, not ours.
So do we maintain a database of all
Nope.
of the emails that have ever been sent by
No.
American people?
No, we do not.
Is there a database from our government that maintains a database of the text messages of all
No.
Americans?
None that I know of, and none at NSA.
And so I think what you have told this committee today is that the problem is not with the NSA that is trying to keep the American people safe. You've told us that you have a 100% auditable system that has oversight both from the courts and from Congress. It seems to me that the problem here is that of an individual who worked within the system, who broke laws, and who chose to declassify highly sensitive classified information. It seems to me that's where our focus should be, on how there could be a betrayal of trust and how a traitor could do something like this to the American people. It seems to me that's where our focus must be, and how we can prevent something like that from ever happening again. Let me ask your opinion. How damaging is this to the national security of the American people that this trust was violated?
I think it was irreversible and significant damage to this nation.
Has this helped America's enemies?
I believe it has, and I believe it will hurt us and our allies.
I yield back, Mr. Chair.
Thank you, Mr. Chairman.
I want to thank the panel. One of the negatives about being so low on the totem pole up here is basically all of the questions that I wanted to address have been asked. And I think I'm really proud of this committee because on both sides of the aisle, a lot of the questions were very poignant. And I hope that the American people and those that are in the room have learned a lot about what happened here and learned a lot about the people on the panel. I can say specifically General Alexander, in my time on the Intelligence Committee, I have more respect for you, and I'm glad that you're the one up there testifying so the American people can see, despite what's being portrayed and the suspicions that are out there, that there's nobody better to articulate what happened and what we're trying to do than yourself. So I want to thank you for that. I'll ask a couple basic questions that I think that might help clear some things up. Mr. Cole, you talked about how the Fourth Amendment isn't applicable under the business records exception of the Patriot Act and Section 215, applicable case law, Maryland v. Smith, etc. And then we heard about how to be able to look at the data under 215, there has to be very specific suspicion that is presented to a court, and that court is not a rubber stamp in allowing us to basically look at metadata, which is strictly phone records. One of the, I think, problems that people have out there is that it was such a large number of phone numbers. And when you testify, when everybody testifies, that it's very specific and only a limited number of people are able to basically articulate who we should be looking at, and then you hear this number of millions from Verizon. Can you help clear that up?
Certainly. First of all, as we said, we don't give the reasonable suspicion to the court ahead of time. They set out the standards for us to use. But the analogy, and I've heard it used several times, is if you're looking for a needle in the haystack, you have to get the haystack first. And that's why we have the ability under the court order to acquire, and the key word here is acquire, all of that data. We don't get to use all of that data necessarily. That is the next step, which is you have to be able to determine that there is reasonable, articulable suspicion to actually use that data. So if we want to find that there's a phone number that we believe is connected with terrorist organizations and terrorist activity, we need to have the rest of the haystack, all the other numbers, to find out which ones it was in contact with. And as you heard Mr. Enkless say, it's a very limited number of times that we make those queries because we do have standards that have to be met before we can even make use of that data. So while it sits there, it is used sparingly.
Did you or anybody that you know at the NSA break the law in trying to obtain this information?
I'm aware of nobody who has broken the law at the NSA in obtaining this information in the lawful sense. There's other issues that we have with the leaks that have gone on here.
And maybe this question is for General Alexander. Based on everything that we've heard today, do you see any problems with either 702 or 215 that you think should be changed by this body?
Not right now, but this is something that we have agreed that we would look at, especially the structure of how we do it. I think Congressman Schiff brought up some key points, and we are looking at all of those. And what we have to bring back to you is the agility, how we do it, and the oversight. Is there other ways that we can do this? But at the end of the day, we need these tools, and we just got to figure out the right way to do it, or the next step. From my perspective, having the court, this body of Congress, and the administration do oversight, I think if the American people would have stepped through it, they would agree that what we're doing is exactly the right way. So those are the steps that we will absolutely they'll go back and look at the entire architecture, and that's a commitment that FBI and NSA has made to the administration and to this committee.
Final question, Mr. Joyce. What's next for Mr. Snowden we can expect?
Justice.
I yield back, Mr. Chairman. Thank you.
Great. Thank you, Mr. Chairman. Thank you all for being here today. You know, This has been a great hearing. I think the American people will have gotten a chance to hear from folks who are actually executing this program in an important way, and they'll have a choice whether to believe Mr. Inglis and General Alexander or a felon who fled to communist China. For me, there's an easy answer to that. There are those who talk about the war on terror winding down. They say we're towards the end of this. These programs were created at post 9/11 to counter the terrorist threat, both for the soldiers fighting overseas and our allies and for us here in the States. General Alexander, Mr. Joyce, do you think these programs are just as much needed today as they were in the immediate aftermath of 9/11?
I do.
I do too, and I would just add, I think the environment has become more challenging. And I think the more tools you have to be able to fight terrorism, the more we're going to be able to protect the American people.
Thank you. We've talked a lot about the statutory basis for Section 215 and Section 702. We've talked a lot and all the process that goes with it. I want to spend just a minute talking about the constitutional boundaries and where they are. We've got FISA court judges, Article 3, Mr. Litt. These are just plain old Article 3 judges in the sense of lifetime tenure, nominated by a president, confirmed by the United States Senate. They have the same power, restrictions, and authority as all Article 3 judges do. Is that correct?
Yes, that's correct.
We have Article 2 here before us today, and we've got Article 1 oversight taking place this morning. I want to talk about Article 1's involvement. There have been some members who talked about the fact that they didn't know about these programs. General Alexander or maybe Mr. Inglis, can you talk about the briefings that you've provided for members of Congress both recently and as this set of laws were developed?
So 702 was recently reauthorized at the end of 2012 in the run-up to that. NSA, in companionship with the Department of Justice, FBI, the DNI, made a series of presentations across the Hill some number of times and talked in very specific details at the classified level about the setup of those programs, the controls on those programs, and the success of those programs. The reauthorization of Section 215 of the Patriot Act came earlier than that, but there was a similar set of briefings along those lines. At the same time, we welcome and continue to welcome any and all congresspersons or senators to come to NSA, or we can come to you and at the classified level brief any and all details. That's a standing offer, and some number have in fact taken us up on that offer.
You have something to add, General?
That's exactly right. In fact, any place, anytime we can help, we will do it.
Great. I appreciate that. I've been on the committee only a short time. I learned about these programs actually before I came on the committee, so I know that members outside of this committee also had access to the information, and I think that's incredibly important as committee oversight members. It's one thing, but I think it's important that all the members of Congress understand the scope of these programs, and I appreciate the fact that you've continued to offer that assistance for all of us. A couple of just cleanup details going last. I want to make sure I have this right. General Alexander, from the data under Section 215 that's collected, can you figure out the location of the person who made a particular phone call?
Not beyond the area code.
Do you have any information about signal strength or tower direction? I've seen articles that talk about you having this information. I want to make sure, for the record, we've got that right.
We don't have that in the database.
And then lastly, Mr. Litt, you made a reference to Section 702. You talked about it as being a restriction on Article 2 authority, not an expansion. That is, Article 2, presidents of both parties believe they had the powers that are being exercised under Section 702 long before that statutory authority was granted. So is it the case that you view Section 702 as a control and a restriction on Article 2?
Yes.
Great, Mr. Chairman. I yield back.
Thank you, Mr. Chairman. I will make this brief. I want to first of all thank all the witnesses for the testimony, for the service, and for all you've done to strengthen and maintain this program. My question, General Alexander, is, I guess, to you and also perhaps to Mr. Joyce. Several times in your testimony you referenced 9/11 and how, and I recall after September 11th, there was a loud challenge to the intelligence community to do a better job of connecting the dots, be more aggressive, be more forward-thinking, try to anticipate what's going to happen, think outside the box, all those cliches we heard at the time. And as I see it, this is a very legitimate and legal response to that request. I would ask you, General Alexander, with you, Mr. Joyce, I believe, referenced the case after September 11th, where there was phone intercepts from Yemen, which enabled you to foil the New York Stock Exchange plot. It's also my understanding that prior to 9/11, there was phone messages from Yemen which you did not have the capacity to follow through on, which perhaps could have prevented the 9/11 attack. Could either General Alexander or Mr. Joyce, or both of you, explain how the attack could have been prevented? Or if you believe it could have been prevented?
I don't know, Congressman, if the attack could have been prevented. What I can tell you is that is a tool that was not available to us at the time of 9/11. So when there was actually a call made from a known terrorist in Yemen to Khalid Mihdhar in San Diego, we did not have that tool or capability to track that call. Now, things may have been different, and we will never know that, unfortunately. So that is the tool that we're talking about today that we did not have at the time of 9/11. Moving forward, as you mentioned about the stock exchange, here we have a similar thing, except this was under, again, the 702 program, where NSA tipped to us that a known extremist in Yemen was talking or conversing with an individual inside the United States we later identified as Khalid Ouazani. And then we were able to go up on our legal authorities here in the United States on Ouazani, who was in Kansas City, and we're able to identify 2 additional co-conspirators. We found through electronic surveillance that they were actually in the initial stages of plotting to bomb the New York Stock Exchange. So to really summarize, as I mentioned before, all of these tools are important. And as Congressman Schiff mentioned, we should have this dialogue. We should all be looking for ways, as you said, thinking outside the box of how to do our business. But I sit here before you today humbly and say that these tools have helped us.
General Alexander?
Yeah, if I could, I think on the Mihdhar case, Mihdhar was the terrorist, the AQ terrorist from the 9/11 plot in California that was actually on American Airlines Flight 77 that crashed into the Pentagon. What we don't know, going back in time, is the phone call between Yemen and there. If we would have had the reasonable articulable suspicion standard, so we'd have to look at that. But assuming that we did, if we had the database that we have now with the business records FISA, and we searched on that Yemen number and saw it was talking to someone in California, we could have then tipped that to the FBI. Another step, and this is an assumption, but let me play this out because we will never be able to go all the way back and redo all the figures from 9/11, but this is why some of these programs were put in, was to help that. Ideally, going from Mihdhar, we would have been able to find the other teams, the other 3 teams in the United States, and or one in Germany or some other place. So the ability to use the metadata from the business record FISA would allow us, we believe, to see some. Now, so it's hypothetical. There are a lot of conditions that we could put on there. You'd have to have this right, you'd have to have the RAS right, but we didn't have that ability. We couldn't connect the dots because we didn't have the dots. And so I think what we've got here is that one additional capability, one more tool to help us work together as a team to stop future attacks. And as Sean has laid out, when you look at this, the New York City 2 and others, I think from my perspective, those would have been significant events for our nation. And so I think what we've jointly done with Congress is help set this program up correctly.
I was close, General, by saying in your opening statement you said that you'd rather be testifying here today on this issue rather than explaining why another 9/11 happened. So I want to thank you for your service in preventing another 9/11. And you mentioned the Zazi case, and you have some very close familiar knowledge of that. And I want to thank all of you for the effort that was done to prevent that attack. Mr. Chairman, I yield back.
And just a couple of clarifying things here to wrap it up. Mr. Joyce, you've been in the FBI for 26 years. You've conducted criminal investigations as well. Sometimes you get a simple tip that leads to a broader investigation. Is that correct?
That is correct, Chairman.
And so without that initial tip, you might not have found the other very weighty evidence that happens subsequent to that tip. Is that correct?
Absolutely.
So in the case of Moalen in 2007, the very fact that under the Business 215 records, there was a simple tip that was, we have someone that is known with ties to Al-Qaeda's East African network calling a phone number in San Diego. That's really all you got, was a phone number in San Diego. Is that correct?
That is correct.
And according to the unclassified report, that tip ultimately led to the FBI's opening of a full investigation that resulted in the February 2013 conviction. Is that correct?
Yes, it is, Chairman.
So without that first tip, you would have had, you weren't up on his electronics communications. You didn't really, he was not a subject of any investigation prior to that tip from the National Security Agency.
No, actually, he was the subject to a prior investigation
That was
several
closed.
years earlier. That was closed because we could not find any connection to terrorism.
Right.
And then, if we did not have the tip from NSA, we would not have been able to reopen that
The
investigation.
case. But at the time, you weren't investigating it.
Absolutely not.
Right.
It was
And
based
when
on
they dipped that number into the business records, the preserved business records from the court order, they dipped a phone number in, and a phone number came out in San Diego. Did you know who that person was when they gave you that phone number?
No, we did not. So we had to serve legal process to identify that subscriber and then corroborate it. And then we later went up on electronic surveillance with an order through the FISC.
And when you went up on electronic surveillance, you used a court order, a warrant?
That is
a
correct.
Subpoena? What did you use?
We used a FISA court order.
Right. So you had to go back, you had to prove a standard of probable cause to go up on this individual's phone number. Is that correct?
That's right. And it's been mentioned hopefully several times today. Anyone inside the United States, a U.S. person, whether inside or outside, we need a specific court order regarding that person.
Right. And Mr. Cole, I just for purposes of explanation, if you were going to have an FBI agent came to you for an order to preserve business records, do they need a court order? Do they need a warrant for that in a criminal investigation?
No, they do not. You can just get a grand jury subpoena, and separate from preserving it, you can acquire them with a grand jury subpoena, and you don't need to go to a court to do that.
Right. So that is a lower legal standard in order to obtain information on a U.S. citizen on a criminal matter.
That's correct, Mr. Chairman.
So and I think this is an important point to make. When this system is set up on this foreign collection, and I argue we need this high standard because it is in a class, or it used to be in a classified setting. You need to have this high standard. So can you describe the difference? If I were going to do a criminal investigation on getting the same amount of information, the legal standard would be much lower if I were working an embezzlement case in Chicago than trying to catch a terrorist operating overseas, trying to get back into the United States to conduct a plot.
Some of the standards might be similar, but the process that you have to go through is much greater in the FISA context. You actually have to go to a court, the FISA court, ahead of time and set out facts that will explain to the court why this information is relevant to the investigation that you're doing, why it's a limited type of investigation that is allowed to be done under the statute and under the rules, and then the court has to approve that ahead of time, along with all of the rules and restrictions about how you can use it, how you can access it, what you can do with it, and who you can disseminate it to. There is a much different program that goes on in a normal grand jury situation. You have restrictions on who you can disseminate it to under secrecy grounds, but even those are much broader than they would be under the FISA grounds. Right. And you don't need a court ahead of time.
Right. So in total, this is a much more overseen, and by the way, on a criminal embezzlement case in Chicago, you wouldn't brief that to Congress, would you?
No, we would not as a normal course.
Yeah, and so you have a whole nother layer of legislative oversight on this particular program. And again, I argue the necessity of that because it is as I said, used to be a classified program of which you want additional oversight. You want members of the legislature making sure we're on track that you don't necessarily need in a criminal matter domestically.
That's correct. In a normal criminal embezzlement case in Chicago, you would have the FBI and the Justice Department involved, and that's about it. Right. In this, you've got the National Security Agency, you've got the ODNI, you've got the Inspectors General, you've got the Department of Justice, you have the court monitoring what you're doing if there's any mistakes that were made, you have Congress being briefed on a regular basis. There is an enormous amount of oversight in this compared to a grand jury situation, yet the records that can be obtained are of the same kind.
Great, thanks. And I just want a couple clarifying questions, Mr. Joyce, if you will. Does China have an adversarial intelligence service directed at the United States?
Yes, they do.
Do they perform economic espionage activities targeted at U.S. companies in the United States?
Yes, they do.
Do they conduct espionage activities toward military and intelligence services, both here and abroad, that belong to the United States of America?
Yes, they do.
Do they target policymakers and decision makers, Department of State, and other policymakers that might engage in foreign affairs when it comes to the United States?
Yes.
How would you rate them as an adversarial intelligence service, given the other intelligence services that we know are adversarial, the Russians, the Iranians, the others?
They are one of our top adversaries.
Yeah, and you have had a string of successes recently in prosecutions for Chinese espionage activities in the United States. Is that correct?
That is correct.
And so that has been both economic and, if I understand it, as well as military efforts. So they've been very aggressive in their espionage activities toward the United States. Is that a fair assessment?
I think they have been very aggressive against United States interests.
General Alexander, how would you describe in an unclassified way the Chinese cyber efforts for both espionage and their military capability to conduct disruptive attacks toward the United States?
Very carefully. With a lot of legal oversight. I think one of the things that, it's public knowledge out there about the cyber activities that we're seeing. But I also think that what's missing perhaps in this conversation with the Chinese is what's acceptable practices here. And I think the president has started some of that in the discussions with the new president of China, and I think that's some of the stuff that we actually have to have. This need not be an adversarial relationship. I think our country does a lot of business with China, and we need to look at how can we improve the relations with China in such a way that both our countries benefit, because we can, and I think that's good for everybody. What concerns me is now this program and what we're talking about with China I think we've got to solve this issue with China, and then look at ways to move forward. And I think we do have to have that discussion on cyber. What are the right standards? Have that discussion both privately and publicly. And it's not just our country, it's all the countries of the world, as well as China.
No, and I appreciate you drawing the line, but would you say that China engages in cyber economic espionage against intellectual property, to steal intellectual property in the United States?
Yes.
Would you argue that they engage in cyber activities to steal both military and intelligence secrets of the United States?
Yes.
I think this is important that we put it in context for several things that I think Americans want to know about the relationship between Mr. Snowden and where he finds a home today. And that we know that we're doing a full investigation into possible connections with any nation state who might take advantage of this activity. And the one thing I disagreed with Mr. Litt today, that they haven't seen anything of any changes, and I would dispute that based on information I've seen recently, and would ask anyone to comment. Do you believe that Al-Qaeda elements have just historically, when issues have been disclosed, changed the way they operate to target both soldiers abroad and their terrorist plotting activities, movements, financing, weaponization, and training?
To be clear, what I intended to say, and if I wasn't clear, I apologize, was we know that they've seen this, we know they've commented on it. What we don't know yet is over the long term what impact it's going to have on our collection capabilities. But you're absolutely right. We know they watch us, and they modify their behavior based on what they learn.
And we also know that in some cases, in certain countries, they have modified their behavior, including the way they target U.S. troops based on certain understandings of communications. Is that correct?
I think that's correct.
That is, well, I'll guarantee it's absolutely correct. And that's what's so concerning about this. I do appreciate you being here. I know how difficult it is to come and talk. General, did you want to say something before we?
Yeah, I wanted to say, if I could, just a couple things, because they didn't come up in this testimony. But first, thanks to this committee, the administration, and others, in the summer of 2009, we set up the Directorate of Compliance, put some of our best people in it to ensure that what we're doing is exactly right. And this committee was instrumental in helping us set that up. So that's one point. When we talk about oversight and compliance, people think it's just once in a while, but there was rigorous actions by you and this entire committee to set that up. The second is, in the open press, there's this discussion about pattern analysis. They're out there doing pattern analysis on this. That is absolutely incorrect. We are not authorized to go into the data, nor are we data mining or doing anything with the data other than those queries that we discuss, period. We're not authorized to do it. We aren't doing it. There are no automated processes running in the background, pulling together data, trying to figure out networks. The only time you can do pattern analysis is once you start the query on that query and where you go for it. You can't go in and try to bring up, I have 4 daughters and 15 grandchildren. I can't supervise them with this database. It is not authorized, and our folks do not do it. And so that's some of the oversight and compliance you and the rest of the oversight committee see. But I think it's important for the American people to know that it's limited. In this case, for 2012, less than 300 selectors were looked at, and they had an impact in helping us prevent potential terrorist attacks. They contributed. And I think when you look at that and you balance those two, that's pretty good.
And I do appreciate it. And I want to commend the folks from the NSA have always, we've never had to issue a subpoena. All that information is always readily provided. You meet with us regularly. We have staff and investigators at the NSA frequently. We have an open dialogue. When problems happen, we do deal with them in a classified way, in a way I think that Americans would be proud that their elected representatives deal with issues. And I'm not saying that there are some hidden issues out there. There are not. But I know this has been difficult to come and talk about very sensitive things in a public way. In order to preserve your good work and the work on behalf of all the patriots working to defend America, I still believe it was important to have a meeting where we could at least in some way discuss and reassure the level of oversight and redundancy of oversight on a program that we all recognize needed an extra care and attention and lots of sets of eyes. I hope today in this hearing that we've been able to do that. I do believe that America has the responsibility to keep some things secret as we serve to protect this country, and I think you all do that well. And the darndest thing is that we may have found that it is easier for a systems analyst or systems administrator to steal the information than it is for us to access the program in order to prevent a terrorist attack in the United States. And we'll be working more on those issues, and we have had great dialogue about what's coming on some other oversight issues. Again, thank you very, very much. Thank you all for your service, and I wish you all well today.
Thank you.